Okay, welcome back. Well, actually, as we also did started by saying, we did invite the PDP to join in that conversation with the APC council, but he failed to honor the invitation. So if they wanted to respond to it, he would have honored the invitation, but that didn't happen. Now we're moving on to politics in Ebonyi State, and the judgment was also handed down where the court did uphold the election of the governor of Ebonyi State. Mr. Silas Ono is here with us. He's a lawyer. He's a member of the PDP in Ebonyi State. Thank you for coming on the program today.
Thank you, Chamberlain. Good morning, Otto.
Well, it's that time again now. You just had different judgments and you're wondering what's going on here. Where's the consistency? Where's the principle? Where's the precedents are they relying on? But, well, I guess they always tell you it is what is before the judges that the judges have got to rule on. And if the councils don't argue that case is right, they'll tell you we can only rule based on what is in front of us. So be that as it may, concerning what went down in Ebonyi, we also have seen dissenting voices here and there about that particular judgment. But clearly, I don't think your principal is accepting that. Tell us if it's going to go upstairs. But what were your immediate reactions when that came through?
Well, thank you very much, Mr. Chamberlain. I was in court on that day, and I followed the proceeding too before the day of the judgment. And the environment would tell you that a party understood or knew what was going to happen before the judgment was even delivered, because you find the APC guys had come with coolers of food, drinks, meat pies with band, ready to celebrate.
I thought that's what politicians do.
No, not for a litigation where you should have some level of anxiety. Whatever the case is, you should have not too confident that, look, this one I've won it, don't worry, you just go, I've won this one. So it's crazy what is happening in this country this electoral season. And then listening to the judgment on that day, one was really, really shocked when you hear a judge tells you that you can bring an election petition, and correctly so, under Section 177 for governorship, which is dealing with qualification, the Constitution 177. And this petition in Ebonyi State was brought under Section 177C of the 1999 Constitution as amended, which is to the effect that the APC candidate, as at the time of the election, was a member of PDP and was not sponsored by PDP.
Which is not what the court thought.
Which the court just threw the thing away somehow, very funny. Now, 177C provides that part of the qualification, A, it must be a citizen of Nigeria, B, a minimum of school cert, C, must be a member of a political party and sponsored by that political party, not another political party. Now, the Ebonyi State case is that the APC candidate, who is now the governor, was a member of PDP, elected to the House of Assembly on the platform of PDP. And then in 2020, the then governor decamped to APC. The parliament was afraid of openly following him, even though they were attending APC activities. The then leaders of the party went to court to have all these members thrown out. And in their defense at the Federal High Court, Abuja here, they said they didn't decamp, that the PDP had no evidence that any of them had resigned or that any of them had cross-carpeted on the floor of the House. Be that as it may, the Federal High Court declared their seat vacant because it's a provision of the Constitution for parliamentarians. When you change party, when the party is not divided at the national level, you lose your seat. They appealed that judgment, particularly the Speaker, who is now the Governor, appealed that judgment in Abuja. And ground 4 of his notice of appeal is that the PDP did not show or prove that he has decamped, and they didn't produce any letter of his resignation from PDP. He went further, all of them went further to approach the Ebonyi State High Court and got a judgment that said they were all still members of PDP and should not leave the house so long as they remain members of PDP. That judgment remained valid until the time APC did primaries, which was more than 3-4 months after that judgment. There's some days to election. A judge that is completely functus officio now purported that he has set aside that judgment after like 5-6 months, that he has set aside the judgment, so that the cloud of PDP will not hang above this candidate.
Well, is there anything wrong with the process of setting that aside? As
of course, if when you give judgment, there is a time limit within which you can set aside your judgment if people complain that it was obtained by fraud or any other reason that are justifiably allowed by the rules of court.
Did anybody challenge that?
Nobody challenged. The people who got the judgment were the people that went as they set it aside. So you see how we play with our judiciary, and it is not going to help this nation at all. So you play with judiciary here, you now come to election petition court, you are still in the court of appeal, and you're still appealing the judgment that removed you, saying you are still a member of PDP, and then you come to the election petition court, and you now say, the Federal High Court has even removed me, so I'm no longer a member of PDP. I have never been. I have resigned. This is my resignation letter. You brought 2 resignation letters. The one you addressed to the PDP or ward chairman was not signed. An unsigned document is worthless. Then the second one, you wrote on your official letterhead paper as speaker, and you address it to APC Ebonyi State that you have resigned from PDP. If you want to resign from a party, do you resign through the opposite another party or through the party you belong to? Now, in order to excuse the conduct of this man, the tribunal categorized section 1777C as pre-election. A provision they had agreed while reading the judgment that it is a ground for which you can challenge pre or post-election. Then suddenly they said, but this challenge is about nomination and sponsorship, so it's pre-election. What is the word used in section 177C?
But
it says sponsored by that political party.
So
if you're sponsored by another political party, it's not a pre-election matter.
You argue that that particular clause should both be pre and post.
They agreed, not me.
They agreed.
They agreed.
But the judge,
the court they kept quoting, which is the Presidential Election Petition Court, the judgment, PDP and APM, that also created confusion. Even in the confusion that the PEPT created, they agreed that for presidential, that section is 131 for presidential. They agreed too that that section is both pre and post-election.
So how then did they then say in this particular matter that no, there's no pre and post?
That's possible. That's the point I'm making. They said it's pre and post. Then they now created another argument that said it is nomination that we are challenging. What do you mean?
Okay, but your party challenged that election on the basis of the governor not being qualified to contest election at the time the election held.
Yes.
But the tribunal judge did that tribunal rule that let me just see if I can just read that clearly. Well, he held that the issue of nomination and sponsorship by a political party being a pre-election matter should have been challenged before the Federal High Court, before the election.
That is the window most of this tribunal used to excuse their inefficiency. Sorry to use that word, right? Nomination and sponsorship is not our problem. Nobody said, nobody is challenging how he emerged the candidate of APC. Nobody is challenging how he emerged. But what we are saying is that APC cannot sponsor a member of PDP, as clearly provided under section 177C.
So the tribunal cannot say that that also borders on qualification?
It is qualification. As at March of this year, that election took place, this man we're talking about paid his membership due in PDP, the month of election. The membership register of parties obtained from INEC, his name is not in APC, his name is in PDP.
Because the tribunal declined jurisdiction to entertain that matter on the grounds that Winfrey, his sponsorship of APC was an internal political matter.
Well, so you see it. So what are we now saying is that the law is of no effect. Qualification section 177C is of no effect.
So let's look at it.
That is what they are saying. So we should just delete that section.
You know, so far...
We should delete it.
Pardon me, did they say it was of no effect because if they decline jurisdiction, it doesn't mean that it's of no effect?
If they decline jurisdiction, where you are saying that someone is a member of your party or sponsored by another party, then they now categorize it under nomination. It means they have made that section of no effect. You see, you can make anything nomination if you want to be mischievous. You can make everything about nomination except the conduct of election. So it means you cannot challenge qualification at all because all qualification issues arise before the conduct of election. Right? All arise before conduct of election. Qualification is not about the voting itself. It's what makes you entitled to participate. So if you want, you can put even certificate issue as qualification nomination.
So let me ask you this question.
All of them as nomination issues.
So let me ask you this question. When your party saw that the governor had been put forward as a candidate of the APC, did your party go to court?
You cannot do that at that point.
No, saying because you just told us here that as at March. This is the election of March 18.
Yes.
But you just told us that as at March.
Yes.
He just paid his dues.
Yes.
Into the PDP.
PDP,
right?
Yes.
But as at March, he had already had the ticket
of APC.
Good. That's what you're saying. Good. So did your party go to court
now,
at that time?
I get your point.
To say this man that is contesting on this platform is still our member.
And that is the interesting part. Because until you participate in an election, do not have locus. Until the election is conducted, it is a candidate who participates in an election that can go to court. Now, if you go to court at that time, it is an internal party affair before election. Only a member of APC at that point can challenge him. And not any member, a member that ran for governor with him in APC. And that challenge has to come up, right? 14 days from the day they conducted their primary election. Somebody in APC did that. One of his colleagues that purported to have also joined APC. He won APC ticket. The person who ran against him went to court, won at the Federal High Court. The man went to Court of Appeal, he won, and then they got to Supreme Court. Supreme Court said, you are still a member of PDP. And that was how that House of Assembly member lost his seat. And this tribunal told us it was a judgment in persona, that only that person can benefit from that judgment. No, the Supreme Court interpreted law. It's not a property case that they went for.
All right, let's bring in Ayo and Buki.
Thank you, Chamberlain. You know, I find it very interesting, and I think I like the angle that Nyota came in all of this conversation. So, for you, what next, Mr. Ono?
Review the judgment and approach the Court of Appeal. Certainly, we will not want a bad precedent to be laid in our electoral jurisprudence. We would like to see the end of this matter. So, to allow this will be to endorse a very, very unjust judgment. This we won't do because of our personal interests. We're doing it for the collective interest of Ebonyi people and Nigerians as a whole. Because the law is the law. We cannot be bending the law whenever it suits us to benefit any individual. We can't do that. There was no question. There was no question that the resignation letter he purportedly tendered, we didn't tender that letter, he tendered it in court, was unsigned. So, and then you hear the court now telling us, oh, we didn't bring his ward chairman. Do we have to bring his ward chairman when he has brought a letter addressed to the ward chairman that was not signed? What is the position of the law on unsigned document? And no comment was made about that.
Well, Mr. Ono, you are a lawyer, so a number of the issues that have been raised.
There are more questions than answers, I imagine, from this.
A number of issues that you have raised. So a number of the angle that people might be looking at it, that it might be interpreted in some quarters would be, are you then questioning, Mr. Ono, the integrity of the judiciary or the position of the judiciary, the tribunal, on this particular case?
Thank you, Makinde. As a lawyer, I have always advocated for the establishment of a constitutional court, because these are tribunals that you find everywhere every 4 years are becoming a terrible jamboree. You remember the case of Osun State, where they were even writing song Buga. You know, you see all of the things they do. You bring judges from Sharia court, you bring judges from customary court, you bring magistrates who do not have the necessary trainings to adjudicate election matters, to come and do election tribunal. It's just like sending people to go and get empowered every 4 years. So many of these people go there just looking for what they will get, not looking to deliver justice. But if we have a constitutional court in place that is permanent, election cases go there, and the only appeal that can arise from that court will go straight to the Supreme Court. An appeal from that constitutional court will require the court sitting in its full complement of all the justices, the Supreme Court, so that you take away the powers of the Chief Justice from nominating those that will be in a panel. If all the justices of Supreme Court are empaneled to review decisions of a constitutional court, you will begin to find consistency in our electoral jurisprudence. I give you an example. You go to the tribunals in Plateau State. There are 2 panels for National Assembly. Go and check what they are doing. They are giving completely inconsistent decisions. One going left, the other one going right, on the same issues. So we must do something about this election petition tribunals or whatever. Many of them don't care about the states they are sent to go and adjudicate, because they are not from these states. They have no interest what happens after they give their decision. Look at the one in Kano, where a judge descended into insulting supporters of a political party, calling them terrorists, calling them all sorts of names. A judge shouldn't do that. So we must deliberately change this position. Remove these tribunals, establish a constitutional court where election matters go to from all states. And from this constitutional court, you go straight to the Supreme Court, and all the justices of the Supreme Court must sit in that panel. Each of them must give his personal opinion on such a matter. That is how we can develop our laws.
Well, Mr. Ono, on the conduct of the judges, I guess it would be hard to query you on that, but on the qualification and the nature and manner of your appointment, I wonder if your position is subject to empirical study. But let's take a second look yet again at the court's decision on your petition, and it's reminiscent, of the ruling on the APC against the candidature of the Labour Party in the presidential election court, where the presidential election petition court ruled against the APC, saying only a political party can determine its own member. Is the same also with the Kano Election Petition Tribunal, where the tribunal also ruled against the APC's petition against the candidature of the NNPP candidate and governor. Are you saying that consistently the judiciary is ignoring, according to you, Section 177 of the Constitution? Because this is becoming precedent for future election petition tribunals that can be cited to dismiss such petitions.
Thank you very much for this very, very good question. Political parties are free without any form of interference to determine who their candidates are. However, in doing so, they must ensure that the candidates they are selecting is also not a member of another party. so that they don't fall short of the provision of Section 177C, where you go on sponsoring the candidate of another party. Where the problem lies here is that this person did not resign from PDP. He didn't. We're not saying APC was not supposed to nominate him. They are free to do so. But ensure that he resigns from PDP properly. That is the whole issue. Let him resign. You are free to join any party of your choice. But when you're living where you were, exit properly. Don't just sit here and sit there. You can't be in two parties. Go and read the case of Uche Nwosu in Imo State. The Supreme Court said you can't be in two political parties. So he never resigned from PDP. That is our own complaint. We're not saying APC, you ought not to sponsor him. You ought not to allow him join you. He's free to join. But if you want to be sponsored, resign properly from PDP. That is the whole case. If you didn't resign, you cannot be in two political parties. So it's not nomination that we're challenging. It is the sponsorship of our member.
Qualification.
He's our member. We keep telling him,
all right,
you have left. He said, I didn't leave. You have left. I didn't leave. He's in court of appeal. That matter is still there till this minute. And he has sought for and gotten stay of execution. Stay of the judgment of the Federal High Court. Yet, this tribunal said, no, that judgment is still in force. This man has stayed it. And you said, all right, Mr. Ono,
we do thank you for coming on. You said you're going to go upstairs on this particular matter to pursue it to its logical conclusion. Thank you for coming on today on the program.